All right, we are live again. Less than 24 hours, Nicole. So this went live in less than 12 hours. And then I was like, wait, the Gold Card website is live. This means people have questions. And then I know there's more update to H1B proposed wage rule, like what does lawyers have to do more stuff and so on and so forth. But before we get started, Nicole, I'm happy to have you back. I'm so excited to talk to you. But maybe you can do a quick intro of who you are, what's Manifest, and then let's get into the topic.
Hi, everyone. So thank you, of course, for having me here, Yudi, and thank you for everybody in the audience who's here to come see us and talk to us about all of the updates. So my name is Nicole Ganara. I am the principal immigration attorney at Manifest Law. A lot of my work has to do with helping individuals like yourself or companies build their futures in the United States. Manifest Law is within, essentially, we are a tech-enabled law firm. We're looking to redefine what legal practice looks like. For many of you, engaging with an attorney feels like a black box. We are there to break open that black box and to make it easier and more accessible for individuals to work and communicate with their attorneys on the stuff that they need to get done.
Nice. Let's dive into. Let's start with H1B, and then we'll start into Trump Gold Card, and then I'll probably have follow-up questions.
Yeah, for sure. Yeah, let's unpack that. So why don't we get started with the H1B wage rules, and we'll go from there.
Yeah, like what's going on? So I know last was that it was in the commenting period. They probably got a bunch of comments, and now it seems like there's. Did we ever got like a final update yet, or no?
No, we have not. So the comment period is over. I bet you what's happening right now is that the government is unpacking all of those comments because they have to reasonably answer like the different buckets of comments that they have. Does that mean that they're answering every single comment? No, they try to kind of consolidate each of them, but we haven't had a final result just yet. But I think all of us know that it's coming. Right. And what I really want to inform every single one of the people in this audience is there's actually two parts to like this concept of an update, right? Number one is the rules regarding increased chances for people in higher level wages in their occupational fields and geographic locations. The other half is this discussion of increasing the prevailing wages that are assigned to occupational category. And those two things are separate subjects. So sometimes people say it's all in one, but it's not necessarily the case.
Okay. And then yesterday in our session, David mentioned that lawyers now have to do a little bit of extra steps for figuring out the prevailing wage and bunch of stuff that lawyers now have to do before even you enter into the lottery. So what's that about?
Yeah. So in the past, registering for the H1B lottery was very straightforward. Passport information, biographic information, and company sponsor, EIN, that's it. Now the government is basically going to ask us, and it's not 100% confirmed that it's going to start at this upcoming lottery season. I just think that more likely than not, it will be. That is the plan. Essentially, to define already the SOC code, so your occupational field for your job, what the job is and what you are earning ahead of time. Now, the reason why this is so important and the reason why it's a lot more work for an attorney is because the question of whether or not your degree or your experience in lieu of a degree qualifies for that particular position actually is tied to that SOC code. Right. So it's actually a deeper analysis. So sometimes you may say, well, Nicole, I'm a software developer. It's just a software developer SOC code. Yes, for let's call it 60 to 70% of the market, it will be straightforward. But there's always that 30% of maybe someone who is a marketing specialist, but their wage might be too low. Or maybe it's that they're marketing specialists, but their background is in physics, right? So in those kinds of scenarios, it's actually intensive work for the attorney to try to figure out what's the better SOC code, what are the arguments that I can make to tie that physics degree to whatever that occupational field is. So yeah, it has changed. There's just a bit more work for that 30% where your role is just not straightforward and your education is not necessarily straightforward.
Got it. Okay. But the basic premise still remains the same, that you get like level 4 gets more opportunity, like more chances in the lottery, level 3, that still remains the same.
That does remain the same in the sense that that's the biggest change, and that requirement or that change is what necessitates that SOC code setting and that level wage setting ahead of time.
Mm.
In the past, we could define all of these variables after the lottery has been completed and you've been selected to apply for the full H1B. Now we have to do all of that, let's call it guesswork or that estimation work before we've even, and you already know how chaotic the registration period is. You only have 2 weeks to submit. So nowadays, us attorneys are actually working ahead of time, whereas before we could probably start this whole season in January, February, and that's more than enough time. We're already reaching out to our corporate clients as early as October, November, knowing that this is upcoming, building up products and tools to try to accelerate this analysis.
Got it. Okay. Yeah, I think I'm sure we're gonna get more questions on H1B stuff, but before we answer those questions, let's do quick on what's happening with Trump Gold Card. Is it really going live? Is it live? Can people start buying their green card now, or like, yeah, what's happening?
Yeah, it is live. You can go onto the government website, USCIS. The forms are there to fill out. They have instructions on where to file it, where to mail it. The website, the trumpgoldcard.gov website, has a method of payment to accept the processing fee, which is so interesting because I think this is one of the first times in my career that I've seen a separate payment page that is outside of USCIS's page, right, in order to make the payment. So
Wow.
it's definitely novel. I don't think any attorney could reasonably say like I've seen this before. No, we have this is like uncharted territory to say the least.
Wow. And so how does it work? Like, I know they have like I-140G form, which is a slightly newer form. So like, yeah, what's the process? Like, can I just, it looks like there's a $15,000 down payment or like deposit. You just have to pay that. And like, does it now go under EB1 category? Do I still have to wait, or like as soon as I paid, like, yeah, what's the process?
The questions that you're asking are the questions that all of us are somewhat asking, but maybe I can provide clarity. And I can also mark where things are still even a little bit confusing, even to us attorneys, right? So number one is that it's still ultimately an I-140 application, right? Essentially, what the government is saying is that if you're able as an individual to make a contribution of $1 million, right? Or alternatively, as a company sponsor an employee with a $2 million contribution, you can apply under the EB1A extraordinary ability category or the EB2 NIW category, but you're substituting all the evidence for this payment. So like that's the way that I think about it in a very colloquial way. Skip the criteria analysis, skip the NIW, all of that analysis of what makes you of national interest. And instead you're showing the money, right? Now you are still in line though for the EB1 or the EB2, right? So even if this I-140G was approved, it's not like you're accelerated in front of everybody on those backlogs and you're now eligible to file a 485. No, upon the approval of the I-140, you're either in the EB1 queue or the EB2 queue. Why they would separate it is unclear, because to me it's like, who's going to pick EB2, right? But then again, Yuri, you and I remember in the past, remember what everybody was downgrading from EB2 to EB3, right? It's like, so sometimes there could be reasons for it, but when I'm looking at this form, I'm like, wouldn't everybody just check off EB1?
Right. Yeah.
Right? But I digress, right? The process essentially is you either make that contribution for $1 million for an individual or $2 million if you are a company sponsoring an individual. What gets a little bit lost is that unlike a traditional I-140, where ultimately when you 485, your whole family can come with you, in the I-140G, your whole family can come with you, but it's an additional contribution per person, right? So if I did $1 million for myself and I wanted to do this for my husband to attach to me, I would need to pay another $1 million, right, for my husband as well. And that also goes with the corporate sponsorship. There's also a lot of other fees that people aren't really talking about. You mentioned $15,000 processing fee. That isn't a deposit. It's a processing fee. That is essentially the filing fee to process this case, right? And then there's also other fees for the corporate sponsorship, the $2 million one, right? There is a 1% maintenance fee on an annual basis. So that's about $10,000, I believe, or is like, sorry, if it's 2 million, whatever 1% of that is. Guys, if I was good at math, I wouldn't be a lawyer, right?
20,000, yeah.
Right.
Yeah.
And all I can say is that I'm looking at this and I'm like, so when does it end? And that question is still out there. Like, when does this maintenance fee end? Is it when you ultimately are in the 485 stage? Is it when you're already walking away with the green card? The other fee that's out there is that if the corporation wants to transfer that I-140 from one employee to another employee, for whatever reason, let's say that previous employee was terminated, there is a 5% transfer fee that is kind of charged to the employer in order to make that transfer. That's basically more or less what we know in terms of the costing, right? All I can say is that I will say that with the way they structured this I-140G, I've delved very deeply to the forms, is that it's very similar to the EB-5 in terms of the requirements for the source of funds. It's not enough that you've paid the money. A lot of the questions on the forms ask whether it's the corporation or the individual, where did the money come from? And the examples that they provide in that I-140G form are substantially similar to the examples that they provide for any person who is approaching the EB-5, with one exception, which is cryptocurrency, which I think is just the government trying to be very snazzy and modern.
But the interesting part is, like, even after paying 1 million, you are still backlogged of EB1, whatever. Like, if you're Indian national, then you're still back like 4 or 5 years.
Yes, 100%. And the other thing too, which makes this kind of a little bit incredulous or a little bit kind of confusing for me, is that they use this term expedited basis, right? They're telling the general public that this is an expedited process to get an I-140. But did you guys notice that there's no premium processing? There's no guaranteed time frame, right? At least with a regular I-140, I can pay $2,805 for some sort of result or adjudication within 15 business days. In this particular one, we have no idea. What is the processing time? What do you mean by expedited processing, right? Because I remember back in the day when EB-5 was relatively new, there was this understanding that it was supposed to be a faster way to get a green card, to raise funds for the good of the economy of the United States. But you all know that EB-5s take like 18 to 24 months to get adjudicated. So is it going to be the same net result? Who knows, right? All I can say is that there's still definitely questions in the air. Whether or not there's a lot of value to the program is also a question, but I think we shall see. There's going to be companies and there will be individuals who want to test this. And here at Manifest Law, we're really keeping an eye open to see what are the results, right? I actually already have some of the application information because I decided to join the wait list to see what would happen. But functionally, at this time, there's not a lot of visibility in terms of how long it will take to process.
Interesting. Okay. All right. Yeah. And I'm sure we have questions from not just Trump card and then, or Trump gold card and then H1B wait. We probably also have questions about the appointments thing. As you know, the whole appointment scenario in India, they rescheduled it. So now people are stuck. And is there a general guidance that you are giving to people who are consulting you that, hey, Nicole, like, I did my biometric, I was in India, and now my interview that was scheduled is now postponed to April 2026. I'm now stuck in India for 4 months. What do I do?
So this is such a tough question because in previous times, we would have been able to say, hey, third country national processing, shop around for an appointment in another country. But we all know that that got rolled back. At this time, I find that you can make an attempt for an expedited appointment, but your company really needs to have your back. What is the business continuity reason? What is the tangible impact of your inability to return to the United States, right? The more that you have data and evidence to back the fact that your lack of presence in the US is going to have a substantial detrimental impact to the company or to the economy, the stronger the chance that you might get an accelerated appointment. But I think one thing that attorneys have all been saying is that I don't necessarily think the Department of State wanted this to happen, right? I think it's that they do have these new processes that they have to implement. So at this time, for all of you who have pending appointments or all of you who haven't even left the country, I've actually been telling people don't leave the country because we just don't know when the availability would start to reopen. But guys, please seriously consider if you are a dual citizen of multiple countries, try to see if there's another country that's available for you to adjudicate your particular application. If you have a green card in another country or the equivalent of a green card, remember that you can actually go to those consulates because they are considered your country of residence. You are not necessarily required to always go to your passport country if you have residencies in other countries as well.
Cool. All right, let's do some Q&A. I'm planning to go to India next summer sometime in June. Should I plan the visit now or postpone it? I'm wondering because most of the appointments from December are getting rescheduled to July. So I'm assuming this person H1B as well.
So I actually have a really good answer for this situation because it's so far into the future, right? You're not moving right now. The one thing that I would consider, Ankit, is essentially, do you still have a valid H1B stamp? So where I'm most comfortable telling people to go for it is, let's say your appointment is in June, but your current stamp is valid until, I don't know, September, right? And you're just trying to renew it because you happen to be going back. In those situations, I'm comfortable with sending you abroad with the risk of the postponement because worst case scenario, if it gets canceled, just come back to the United States on your existing valid visa. But for now, I don't necessarily think you should feel too worried because it is all the way in June. I think that a lot of the implementations will occur. The only reason why all of these December and January appointments have been rescheduled is because they just need that lead time to make that implementation. It's probably more likely than not that you're going to be safe.
And aren't they just going to give 221G to everybody? I mean, essentially.
For many people, potentially. I think the problem with the Department of State is that they're like an iron curtain. We usually don't get a lot of insights into why they do things, how they do things without doing like a massive FOIA. So we'll find out like a month or so later, unless you have some insider information. If you get into a 221G situation, like the most unfortunate part is that you will have like very little visibility. Right.
Yeah, the context is like because this is the same thing they did with F1, right? Like they paused the appointment and then essentially what they did is like regardless if you're approved or not, they'll give you 221G so that they can do the social media vetting. So I'm assuming they're going to do similar thing. This is my assumption, but
they could. I just think that we'll have way more insights by next summer. So I think when someone is posing a question of something that's so far, I think for now, you're probably going to get a lot more details leading up to that point to make a better judgment call. It's just my gut feeling is that by then things should probably stabilize a little bit better.
Yeah. Someone pointed out that Indian nationals are not backlogged. Only people who are born in India are backlogged. Nationality plays no role. Correct. Yes. Sorry.
That is 100% correct. Yeah. The reality is that it is Indian-born nationals, right? I will also say, if I wanted to add other countries who are facing a backlog, Chinese-born individuals, right? Individuals who are born in like mainland China and the like, that's where they get another set of backlogs.
Yeah. Is H1B based rule officially into effect for March 2026?
No. Essentially, the government wants it to be, and I'm like with 90% assurance it's going to be, right? Given like the timing. But if you're asking me, was there a formal announcement that says for a fact this is going to be in effect for this year's lottery? The answer is no. I haven't seen that personally. But every single individual should be anticipating it. All of the firms are anticipating it, which is why maybe for some companies, you'll see an increase in fees for the lottery enrollment for this particular cycle.
Just wanted to check if I have an appointment in Mexico this month. This was booked in July. Can I still consider going? I don't have visa stamp in my passport.
I would not go. I've made that very clear given the tumultuous of the current situation, right? I understand that you have an appointment in Mexico. I am curious on whether or not you have the right to have your appointment in Mexico, because I know it hasn't been canceled just yet, but do remember that the policy so far has been third country national processing is out. So unless you can prove that Mexico is your country of residency, I am worried about you getting a 221G or some sort of denial administratively because they want you to go to your home country. But setting that aside, it's too risky right now to go this month. I would rather you stay in the US in order to maintain your role in the United States.
All right. Cool. Can you explain new H1B wage rule changes and when they take effect? Specifically, I'll be graduating in March 2026, starting to work on OPD shortly after. If an employer wants to sponsor me for H1B in April 2026 lottery, will the new wage requirement apply to that filing, or does it depend on a different timeline?
So I want to make it clear two different things related to these wage rules, because I feel like a lot of people are confused. There's number one, the increase in chances if you have a higher wage within the wage scale. So if you have a level 4 wage, you'll have 4 chances, level 3, 3 chances, and then so on and so forth. The other half of a lot of the discussion is the potential increase in the prevailing wages, which is like the minimum wages that apply to an occupational category. So if you're talking about the chances where you have a higher chance of winning if you have a higher wage in your geographic location and field, then the answer is that that's likely to take effect in this upcoming lottery. What does that mean for you is that it could lower your chances if you have an entry level role, right? Or a salary that just doesn't really match up with some of the higher categories that are out there. In terms of the other side, which is the prevailing wages, right? That the minimum wage to even barely be eligible for that occupational field is going to be higher. I don't think that that's going to impact this upcoming lottery. And it's because the wages have already been set all the way through to June 30th of next year. The way that the Department of Labor works is that they adjust these cycles every June 30th. So I can see them changing it for the next cycle, not necessarily this cycle.
Yeah. So again, PB, what we are saying is this, we are assuming that 90% of chances that this new rule might go into effect. And that would mean that you may have lower or higher chances depending on your salary. But Nicole, they haven't clarified what happens to people who are living in a remote town, like my town. It's like super small town. So over here, $90,000 is equivalent to like level 4, maybe level 3. So is that going to be considered my town, or even though my company is in Chicago?
Yeah. The way that it's written and the way that even like how the LCA works is that it's based on your geographic location, right? So that's the reason why I'm a little bit sensitive to like this particular rule. And remember that the whole point of the notice and comment period, right, is that the government can still make adjustments to these rules based on those comments. It's very possible that some companies or certain firms have flagged this as an issue to the government, because what is stopping a company from just setting up an office in the middle of nowhere in Alabama, and suddenly your Silicon Valley wage is a level 4 wage no matter what? You win the lottery because you have 4 chances, and maybe even more if you have a master's degree, and you work in Alabama for 2 weeks. What stops you from filing an H1B amendment or an H1B transfer to adjust the role? Right? So the reality is that this is where things kind of are not necessarily confusing, but give me pause about this rule, because I feel like it's very easy for companies to just say, well, I have this office in the middle of nowhere. That's exactly what you just pointed out.
Yeah. So again, to clarify to everybody, the new final rule has not yet been published. They are behind the scene. They are working on all the comments and like finalizing what that new rule looks like. But we do think that they're targeting this lottery, this upcoming lottery. Is that right, Nicole?
Yep, that is accurate.
Okay, cool. Will living in United States for 14 years as an L1 dependent negatively impact my chances for getting an F1 visa? Ooh.
I have so many questions because 14 years is a really long time. Like, is it that your partner happened to get an L1A twice? Like, I'm just trying to think, like, how do you extend your L1 so long? It's like an intermittent L1, which is very interesting. I do think it gives pause because 14 years is a really long time, right? One thing I will say though is that a good attorney, if they were to prep you for this interview for an F1, or they were to make an argument for a 539 that changes status to F1, they'll say, listen, the entire time this person was a dependent, they could have sought a green card. Like their partner maybe was on an L1A, could have sought an EB1C, or their company could have permed them. I would use that as an argument to say, well, that shows my lack of interest of being a permanent resident. But I will not lie to you that 14 years is a really long time, and they're allowed to question your intention or at least your ties to your home country if you've spent over a decade in the United States.
Yeah, 100%. This is kind of what you were referring to. H1B is valid, or stamp is valid till September 30. Say I'm able to get an appointment in September or August, but that got rescheduled and I come back. Won't it be a problem at port of entry considering less than a month left on my visa?
So remember that your visa stamp is Franklin entry document. It's not necessarily your validity date per se, right? Because there's always two documents that control your authority in the United States. The H1B visa stamp, the entry document, what allows you to travel into the United States to effectuate your H1B status upon that entry. And then the actual, let's call it I-797, the approval notice that allows you to essentially prove that you're eligible for this H1B status, right? And for how long. So even if you only have a month left on the visa, you can still enter the United States because your entry document remains valid. It's the underlying 797 that controls how long you can technically stay in the US. So I don't think you're going to have a problem. And I think one thing that people don't realize, and I'm here to share, is that even if your H1B visa stamp was issued for a different employer, right? Let's say I started working with Google, and that was the first H1B visa stamp that I had that's valid for 3 years, right? But 2 years in, I changed jobs and now I work for Meta. You can still travel on that H1B visa stamp that was issued for Google because it's just an entry document. Controlling authority is your 797 when it comes to your validity in the United States.
Yep. Okay. Along with H1B, are they going to change prevailing wage for green card during perm, or they remain the same?
So prevailing wages and all of that database cuts across anything that touches the Department of Labor, right? So that means H1B and perms. So I don't know in what stage you are in, Vamshid, when it comes to your perm process, right? If you've already exceeded the prevailing wage determination step, you should be okay. But anybody earlier than that may be impacted by any changes in the future when it comes to the increase in the prevailing wages, should it come through.
Okay. I have an appointment scheduled for Jan 2026. Should I reschedule? I think there's a lot of questions, same. Like this time.
I don't know about rescheduling. I think it's one of those things where it's a risk tolerance question. You can definitely wait it out to see if the government automatically reschedules your appointment. It's unclear like what, I wouldn't say algorithm, but what makes them determine who gets rescheduled and who doesn't. Because I have clients who are going in India whose appointments on December 15 and 16 still remain the same. So it's like, which is very interesting, right? I haven't been pinged about it and I'm very confused, but I'm like, let's see what happens. But they're already in India, so I can't really recall them and they don't have a valid visa stamp. But I think my rule holds true. If it's not essential for you to exit the country and you're more comfortable with staying in the United States, it is not worth the risk of you going to this appointment, because even if the appointment still stands, right? Yudi mentioned this earlier. What if you get that 221G? What if you get put into administrative processing? I think every single one of you in the audience knows somebody who did admin processing, and you know it's a black hole. Is it going to be 1 week, 2 weeks, 8 months, 2 years, right? We've all seen it happen.
Yeah, I think a lot of people have same like appointment on 27 Jan, 25th Jan. In general, in Jan, should they travel or do I need to worry? I think, I mean, Nicola, I don't want to speak for you, but it feels like Jan, maybe they can wait and watch until like we get some more official communication from consulates.
Yeah, I think so too. And there's also a lot of anecdotal information that's going to come out to that point. And I know a lot of people worry, like, oh, is anecdotal information good enough? But I think it's all we're going to get for a while, right? And it can also help inform you of those judgment calls. Anecdotal information was really powerful during that 100K proclamation when people were trying to travel back in. Is it working? Is it not working? Does it impact H1B ones and all the other types of things that are kind of tied to an H1B? That was a very, very powerful source of at least first person evidence, right? But for these kinds of questions, like I still hold it in my heart of hearts that the people who have the most defensible position or the ones who have lowest risk are the ones who are not traveling, right?
Mhm.
Every single one of my corporate clients, there was a huge policy discussion, right? If my employee wants to travel who is a foreign national, what do I tell them? And I basically made it very clear, like, I understand that all of us want to travel, that we have a lot of existing needs or like visiting family that is needed, but it kind of comes with your own risk because these kinds of changes can really impact your ability to continue your role. If you are a mechanical engineer working directly in a factory to maintain those operations, no amount of remote working is going to help you, right? So
Mhm.
please be extremely mindful of the fact that unless you have that valid visa stamp, there's almost no guarantee of your ability to re-enter and get this visa stamping done. So non-essential travel really should be avoided because the most defensible position and the most conservative position is to be in the United States.
Yeah. Yep. I got through H1B via NTO in 2025 while I was still in living in Canada. I'm a Canadian permanent resident. I'm in US right now and also studied here. Can I still only go to my home country, India, for interview appointments?
Oh, if you're a Canadian permanent resident, then congratulations, you can go to Canada if you would like to. But the funny thing is that people don't seem to realize that Canada's appointment availability is not exactly great either. And the only reason why I'm saying that is because usually Canadian citizens don't even need a visa. They just kind of show up with their passport and the approval notices. So the staffing or the appointment availability in the various consulates in Canada is actually more limited than you expect. However, if you feel that the appointment availability or you find out that the availability is much wider in Canada, and it will be much wider if you have flexibility to travel to any of the consulates, whether it's Vancouver, Toronto, Calgary, and the like, then go for it. Because when they ask for that question of country of residence, you're a permanent resident of Canada. You are a resident of that country.
Yep. Yeah. Okay. 100K fees, H1B fees is only for who applied from outside US or looking for job directly in US and not for those who come in US in F1 visa and later converted into H1B.
Okay, so I do want to make it clear that if you are in the United States on an F1 and you file to change status to the H1B pursuant to a cap selection or winning this upcoming lottery, according to the guidances that were published by USCIS on their website on the H1B, you will not need to pay this $100,000 fee. Changes of status are exempted from this $100,000 fee. Where you are not exempted is if you are outside of the country and you sought consular notification for this particular H1B. It's actually a very limited pool of people, Yudi. And for many people of you in the audience, I think you're very well aware that it isn't necessarily hard to do a change of status if you have a pre-existing job category, sorry, visa category in the United States.
Yeah. Yeah. Yep. All right. When does location affect wage level and can we change it before filing LCA? With so many comments opposing it, could the rule still change before finalization for the next lottery?
So you cannot change it, at least based on the way that the guidances was provided on that proposed rule. That's the reason why there's so much upfront work now for the attorneys with the registration, is because we have to set the location, we have to set the SOC code, we have to set the wage level before we even can enroll you in the lottery. That's why we're working so hard early on, because the company and you must commit to that location, right? It's one thing if you change locations within the same, what they call metropolitan statistical area. So let's say I'm in Manhattan, I'm in the Lower East Side, and now my office is going to move to Midtown. That's fine. We can fix it later kind of situation. But in terms of like changing it dramatically, not at that stage. You have to commit to it, get it approved, and maybe post approval after activation on October 1st, you can file an amendment to change it to a different locale. But I really want to make it clear. Notice and comment period only recently ended. It is very true that the rule can have some changes before finalization. But I know that there were a lot of people opposing it, but always remember the purpose behind this initiative, right? The reality is that the government does have the discretion to make these changes. Is it possible that lawsuits could occur? Is it possible that someone would try to really push for an alternative change? Absolutely. But as it stands, I don't necessarily see a dramatic shift. I just see maybe some adjustments to close up any loopholes, or maybe things to kind of acquiesce certain voting constituencies, let's say.
Yeah. When do you think they will have it? Like when is there a timeline that they are going to follow? Like by Jan, are they going to be like dropping the bomb like right before the lottery season?
That is such a good question, Yudi. I don't have an answer, unfortunately, and I wish for every one of you in the audience that I did. Like, I wish I had like this magical crystal ball or be like an oracle looking into the future. Is it horrible that I have a gut feel? I'll tell everybody here what my gut feeling is, right? They're gonna drop it at a time when everyone is busy doing something else. Or right before the holidays, right? And that's because like even if anybody wanted to make adjustments, or even if anybody wanted to, like, I don't know, I'm not saying that they will sue, but if anybody wanted to sue or try to stop this from happening, they wouldn't be able to if they dropped it on a Friday, or if they dropped it right before Christmas, right? When everybody is out of office. So my gut is like, are they going to make these adjustments on Christmas Eve? Or are they going to do it in that magical week between Christmas and New Year's, right? So I think everybody should have their phones stuck to their hands in that week between Christmas and New Year's, because I bet you that that's when all of the new stuff is going to come out. I know UDU regulatory agenda is talking about this whole modernization of EB1As and EB2NIWs, right?
Yes, yeah,
and we know it's coming, and they're like, December, January. Mark my words, it's all going to be on the same week. There's going to be so much discussion about it. I can already envision it.
Yeah. Nikhil, I think we already covered this. It's not in effect yet. Commenting period has ended. And then for students who will be entering into our H1B lottery for the first time, will it be wage-based? If the rule goes into effect, then yes, it will be wage-based. Sorry, Nicole, I already stole your answers.
No, it's okay. And I think what I would like to tell Nikhil is that you should just do your best to anticipate it becoming into effect, right? The people who are the most prepared are the ones that are accepting of the most conservative position, right? So if you take, and for many people, is it technically the worst case scenario? Maybe. If it's to you the worst case scenario and you're prepared for it, that means, hey, you knew it was coming, you're prepared, you're going to overcome it.
Yeah. Okay. My H1B application got picked in this year's lottery, and now my I-129 form is also approved on 25th November. So can you tell me how can I travel to US since my project gets changed with the same MSA area?
So I don't know what you mean by travel to the US, because does this assume that you're currently outside of the country, and like were you approved as a change of status? Like, so let's just say you had a visa stamp, or even if you're in the US, if your project or your role changes location, but it's in the same metropolitan statistical area, there are rules that the Department of Labor has laid out in order for you to adapt that change. So the good news is that you don't need a new LCA. So you don't need to file a new one, but there's two main actions. First of all, your existing certified LCA needs to be posted in the new worksite in two locations again. Right? So the actual copy, not the posting notices. The second is that there's a few changes that need to be inserted into the public access file that is associated with your particular case that your employer is supposed to maintain. There's a memo that needs to be included, copies of certain instructions, and evidence that that LCA was posted in that new worksite. This is actually a very nuanced process. I highly recommend that your employer talks to the counsel that helped them prepare the H1B. If not, I think a consultation would really serve you guys very well, because it is really important, especially in this day and age, to maintain that public access file to full compliance.
Yeah. And that reminds me, everybody, I do have link for free consultation. So if you have any other questions on any other immigration needs, link is already, I'll paste it right here as well. So that way you can schedule it. There we go. Okay. There were a bunch of other questions. So if I have valid F1 visa till 2028, can I enter US with that visa and I-797 or I-20 valid August 2026 in case I'm stuck in USA? I think he meant stuck in India.
Stuck in India. So that depends on whether or not your I-20 truly is valid, because I'm kind of confused about why you would be stuck in India at the moment if your F1 and your I-20 remains valid. Is it that you have an H1B with consular notification that you haven't activated yet, and you were trying to get the stamp and you're trying to come back to the US, but you still have, like, let's say valid OPT or valid like STEM OPT? In that scenario, so long as you still have that valid F1, that's number one, the stamp, right? Number two, your F1 I-20, the actual I-20 remains active, right? You're either going to school still, or you have valid OPT, or you're still in valid STEM OPT and you've been maintaining it, then I don't see a reason why you wouldn't be able to return to the United States. Where that breaks a little bit is if you filed, let's say, for an H1B and you sought a change of status and that change of status is already approved, then that I-20 has been dead already, because SEVIS has already been notified that your H1B change of status has occurred. You are no longer in F1 status and the I-20 is no longer active. If you want to double check, Sabrata, I would highly recommend that you contact your school, because even if you have what you think is the most updated document, it may not be. Your DSO or International Students Office would be the best person to know.
Yep. Yeah. What's the turnaround time for O1 looking like based on your current experience?
It's always an interesting question. I will say it depends on your baseline. Like, obviously, if you came to me and you already won a Nobel Prize, then I'm going to be able to turn that around in like a week, right? And if you come back to me and you already have like really, really strong categories and you're famous in your industry, of course, those things are going to be fast, right? But if you're not really at that scale yet and there's a lot of groundwork to do, it can take a reasonable attorney anywhere from 4 to 8 weeks, maybe even 3 months to put together the filing. It really just depends on what we're working with. The more nuanced the application, the longer it does take. I don't think people realize this. O1s, as much as there might be certain kinds of templates, a lot of things that can be, let's say, arguably recycled, it's not that simple. I have to tell the story of you, right? Your extraordinary ability within your industry. That doesn't necessarily come across well if it's templated. One cloud architect does something that is usually a little bit different from another cloud architect.
Yeah, 100%. Yeah. Okay. Is new H1B considered change of status if you were initially laid off, filed a change of status to B2, and then change back to H1B? If B2 is pending, there's no valid status. Will H1B be approved with consular processing? Oh, interesting.
I know this domino effect story very, very well, especially during COVID, because this happened a lot, right? So this is what usually happens, and it's something that an attorney should honestly really strategize with you. So you had your H1B, you got laid off, you filed a change of status to B2 to buy more time on your grace period. That's normal, or to be a defensive mechanism, right? You decide to file a change of status back to the H1B thereafter, layering it on the pending B2. Usually what would happen is that the H1B will get an RFE, especially if you seek premium processing, because there isn't really premium processing for the change of status to B2. Because USCIS will say, we cannot necessarily adjudicate this change of status because this B2 remains pending and you're not changing from what is a valid status. You're changing from a pending status. The RFE will basically say, we need you to prove to us that the B2 has been adjudicated before we can actually approve or continue with this H1B. process, right? Now, the problem is under the Biden administration, they actually did their best to consolidate the files. They would actually say, we're going to adjudicate the B2. And we're going to do that. Under this administration, no, they're like, you have 90 days on this RFE, right? You have to hope for the best that it's going to be adjudicated. So my recommendation sometimes in this situation is to file the H1B in regular processing to wait out the B2 pendency period. And I know that sucks because the reality is your employer may not be willing to wait, but there is no functional mechanism to force the government to adjudicate the B2. Now, you could ask for the H1B to approve with consular processing, but my worry is the 100K fee, guys, right? Remember that even if you had that previously approved H1B prior to then, right? If it's not a change of status and you don't have a valid visa stamp, because that's the other exemption, right? Essentially, it's possible that you would face the 100K fee in that consular notification. But honestly, talk to an attorney. You're going to have to unpack every single element of this. And the logistics is very important, getting that done to the best of our ability.
Perfect. Last two questions, and then I'll let you go. First is, after submitting my EAD card application, is it possible to change the delivery address?
I don't know if you filed it with an attorney using a G28 or not. You can submit an AR11 and you can submit an e-request. However, this is more of the practical side of experience. Even if you did all of the right things to change the address, there is a good chance that they're still going to mail it to your old address. So I highly recommend to USPS because they use USPS to mail all these things, a forwarding address, right? So if your previous address is no longer going to be your address, go to USPS, submit your change of address request, right? So that they will automatically forward any mail for your name going to add to that address to your new address. That's what I tell every client. You can submit the change on the AR11. If you have an attorney, the attorney can try to submit an e-request to change the delivery address. But third thing that you should do, USPS change of address or forwarding address requests.
Can I do day trading on H4 visa without an EAD, or will I need an EAD?
Oh, this is always such a tough question, right, Beauty? The number of times I've had students being like, what about Robinhood? What about Coinbase if I'm trading cryptocurrency, right? There isn't really a formal government opinion on this, right? I think what I always tell every single person is that if you're treating this like a 9-to-5 job, right? Which sometimes day trading can be because you're sitting there in front of your computer, you're looking on all these charts, or like you're trying to make quick trades to like make a little bit of money on the side. It can come across as work because how the government determines whether or not you're lawfully working or unlawfully working isn't even a matter of income. It's the matter of how active you are involved and how passive you are in the involvement. For people who are trying to be conservative and the most compliant, especially under an administration that believes so strongly in enforcement of this compliance, I always tell people, try to trade with a broker, some sort of intermediary function, right? I know that might feel like it defeats the purpose of day trading. I totally understand it, but this is not the time to have that one officer who's looking at your stuff to say, well, this feels like you're taking a full-time job without having a full-time job.
Yeah. And this is for previous person. You can change it on an official USCIS address by going to the link. It looks like their friend did it. So maybe take a look there.
Yeah, so that's the reason why I asked. It depends on who filed it, right? Because sometimes when an attorney has a G28 on the file, there are some circumstances where the official account is not necessarily linked. I've had a lot of corporate clients have this issue. You can update it on the official account, but please do know this is just really much practical guidance. I think all of you know somebody where USCIS accidentally mailed it to the old address or sent it to some other person that you don't even know or have any semblance of an answer. Even for us attorneys, when we change addresses, let's say we had a Miami office, we closed the Miami office, we're moving to New York, the number of times that the letters still get mailed to the Miami office is insane. Right? So I am telling people that I try to do a third level of conservative kind of movement, which is that in addition to all of the USCIS official mechanisms, don't forget that all the mail is done with USPS. Change the forwarding address or update a forwarding address with USPS, and that will also get the official mail forwarded to you, at least use that as a safety net.
Yeah. All right. Sorry. Last question, I promise, and then
No problem.
I have my visa stamp from my old employer. Can I go to India and come back on same visa stamping, which is valid until September 2026? I'm working with new employer right now. Stamping is with old employer.
So I'm a little bit confused about what you mean by your stamping is with your old employer, right? So is it that you booked the stamping appointment while you were working with your old employer, and that the information that you submitted on your DS-160 and the information that you submitted in the appointment request was your old 797? Or is it that it's you booked the appointment and you change, like, I basically, do you do what I'm asking, right?
Yeah.
Which is like, I need to understand kind of like the logical sequence of events, because it does primarily depend on the information that you provided to the appointment request. Under Biden, I would have been like, oh, no problem, just show up with your new visa, like their new I-797, no big deal. Under this administration, I have this really strong sense and experience that they want everything to be tied together, right? Whatever you submitted in the beginning for the 797 needs to remain the same. If the scenario is that you submitted old information back when you first made the appointment, but now you have new information, there are ways for you to reach out to the consulate to submit a request to make some of those amendments. It's just that I don't know based on the context you're providing. So this is where a consultation with an attorney would be really, really helpful. Whoever your employer or your new employer utilized to get you that could also be a really great resource.
Yeah. It to me feels like the example you gave, like Google and Meta. It looks like he had a stamp from old employer, wants to renew it in September 2026. So can he come back with that same old stamp? But again, it could be, we need more clarification, and that's fine. Okay. Last question. Does one have to make social media profile public just before H1B renewal, or keep it public all the time?
Oh man, these social media vetting rules, right? So, there isn't like a demarcation line. And I think that it isn't unreasonable that leading up to this announcement, your social media was private because you didn't really feel the need or knew that having it public was of utmost importance. My opinion in being very conservative and putting people in the best position is to make it public all the time, right? And the only reason why I say it that way is because what the government is looking for in foreign nationals are people who have nothing to hide, right? I understand that that's uncomfortable. I have my own social media as private. And the reason is because since I talk so much publicly and I meet a lot of people publicly, there's always going to be parts of my life that I want to have segmented for other people, right? Whether it's my husband, my husband's family, my family members abroad, and the like. But the reality is that I think they want people who are an open book, and you should be comfortable with their being outside for the open, unfortunately, because it's like you have nothing to hide. That also leads me to the other point, which is be careful with what you're posting, be careful with what you're liking, right? Be very mindful of the kind of circumstances that we are in today, right? You can still have fun. You can still travel the world. You can go to Cancun with your friends, right? I think it's really more so that social media needs to be a curated space, right? It should be a reflection of maybe the best of you, right? And not necessarily the most controversial parts of your life.
Yeah. All right. That was fun, Nicole. Again, thank you so much for talking through some of these things. And I know I'll see you again in next weekend, unless Trump decide to do another announcement. Who knows?
I can only tell everyone in this audience, I did this crazy 3-hour-long live stream after the 100K proclamation dropped, right?
Yeah.
I think I've built myself up to be prepared for these things. I have a travel kit now for these webinars and presentations because I know it's going to come at any time.
Nice. All right. Awesome. Thank you, Nicole. And thanks, everybody. We'll see you guys next week. But all right, we'll keep posted, everyone. Yep.
Nice.
Nicole, if you want to stay just for a second and